Tēnā koutou, kia ora koutou katoa. Welcome, distinguished guests, academic colleagues, students, supporters and friends to the inaugural professorial lecture of Yvette Tinsley, Professor of Law at the Faculty of Law. My name is Professor Grant Guilford, Vice-Chancellor of Te Herenga Waka, Victoria University of Wellington, New Zealand's globally ranked capital city university and New Zealand's top-ranked university for research quality. And it's my great pleasure to host you all this evening. I'd like to briefly introduce Professor Tinsley before handing over to her to deliver her lecture. Professor Tinsley completed both her Bachelor of Laws with first-class honours and her PhD in law at the University of Birmingham. She began her academic career in Birmingham before joining Te Herenga Waka as a lecturer in 1996. She became an associate professor in 2011 and a professor in 2019. Professor Tinsley is a leading scholar in criminal justice. Her teaching and research interests are focused primarily on criminal law and justice, evidence and law and forensic science. Her research has influenced government strategies, law reform and judicial decision-making. In particular, her work on jury decision-making and sexual violence reform has had a significant impact both in New Zealand and internationally. Professor Tinsley has published numerous articles for journals worldwide on criminal law and justice, and in recent years has published extensively on the topic of how judicial communication with jurors can be improved. She's established a well-deserved international reputation as a leader in her field, and this leadership has been recognised in a number of ways, including with invitations to speak at the House of Lords in London and to conduct judicial education seminars in the UK. She is a regular speaker at international and local conferences, has contributed to numerous reports and is the editor of several highly regarded books. She has been the New Zealand academic representative for the highly prestigious International Penal and Penitentiary Foundation since 2015 and is a steering committee member for the International Research Network, Law, Gender and Sexuality, including editorial board membership of the network's journal, Society and Social Change. Professor Tinsley is also recognised for her dedication to her students. She is an outstanding teacher who is deeply committed to ongoing curriculum development and to innovation in assessment. She has also excelled as a postgraduate supervisor. Yvette is very active in external engagement and has built strong relationships with a wide range of national and international organisations. She has lent her expertise to steering groups, advisory groups and committees run by the New Zealand Law Commission, the Ministry of Justice, the Chief Victims Advisor, the New Zealand Defence Force and the New Zealand Police. She has been consulted by counsel in numerous cases, including most notably with regard to jury behaviour in litigation relating to the Hillsborough disaster. She has been an expert advisor for law reform projects in Spain, the UK and the US and several states in Australia, most recently as an invited expert to 2 roundtable feedback sessions on open justice for the New South Wales Law Reform Commission and Sentencing Council Secretariat. Professor Tinsley regularly engages with the media and in recent years has featured in 2 documentaries on sexual violence reform and homicide, as well as advising on jury behaviours for an interactive documentary series on the English jury system. Here at Te Herenga Waka, Professor Tinsley has made an invaluable leadership contribution to the Faculty of Law and to the university as a whole. She has served on numerous committees, strategy groups and working parties. She has been the chair of the Puppeteer Human Ethics Committee, chair of the Law Research and Postgraduate Committee and Associate Dean Research. In this lecture, Yvette will examine the harm caused by the adversarial criminal process in its attempt to be objective about deeply personal aspects of people's life stories. Reflecting on her own journey with criminal law, she will argue that accepting the limitations of the legal reform model might reveal ways to address the challenge of making criminal justice better. Please join me in welcoming Professor Tinsley to the podium.
Tēnā koutou katoa, ni samula vinaka, kushti divas, good evening. Thank you so much for that lovely introduction, Grant. And I have brought along my water bottle, as Grant was laughing at me as I was walking through, because I've decided this is my home, this lecture theatre, and so I'm just doing things as I normally do them. Normally would have a cup of tea as well, but I thought that might be taking up things a little bit too far. Thank you to everyone for coming along this evening. I've had quite a bad throat, and our faculty manager, Carol Sorensen, suggested that maybe I could do the lecture by way of interpretive dance tonight. You'll all be very relieved to know that my voice is back. We don't need to do that. You don't need to see my rather groovy moves that I'd come up with. So it's often said that an inaugural lecture is a difficult beast. And, well, it really is. I've learned that through trying to write this one. But it's also a wonderful opportunity for me to force my children to actually sit and listen while I go on about the things that I'm passionate about, because normally they roll their eyes and walk away. It's also lovely to see family, friends, colleagues, all of the above, sitting here in this lovely full room, and I do hope that I do justice to you spending your hour with me today. There are some notable absences tonight. My parents and sister are stuck in the UK because of COVID, but the title of my talk pays a little homage to my parents and their tolerance when I was a teenager of writing probably usually angst-ridden song lyrics all over every square inch of my bedroom wall. And people who know me will not be surprised by that, and I can see that there are some ex-students in the room who have been subjected to my post-punk new wave song list that fit with criminal law and criminal justice. I am very sorry for doing that to you. I'm not going to stop doing it though. So it's perhaps fitting that the title of my lecture is an adaptation of a song lyric that evokes for me the current failings of the criminal justice process. The song, by a group called Tears for Fears, and only the older people will know who they are, was named after this particular drawing, Henry Moore's Pale Shelter Scene from 1941. It's quite a bleak depiction of people coming together to avoid harm from enemy bombing, having a pretty miserable time while they're doing it. And we know that in the shelters there was often overcrowding, illness, harms that were committed by fellow occupants, and that sounds familiar to me as an experience of the criminal law. The song goes on to lament that instead of love, they are given not only pale shelter, but also cold hands. In its attempt to be objective and stand back from the emotion of criminal cases, I think the criminal law most definitely has icy cold hands. So tonight, I'm going to start by unpacking this idea of the criminal law and justice as a pale shelter, looking at how it creates harm and dehumanises while it adjudicates and punishes on the behalf of the community. The ill effects of the criminal justice process for victims and defendants, particularly for Maori and Pacific peoples, is well established in New Zealand, and legal reform efforts have obviously and rightly focused on victims and defendants. So I will start there. But tonight I don't want to spend all of our time talking specifically about the harms caused to defendants and complainants by the criminal process. They are well documented and understood for the most part. Instead, I'm going to spend some time illustrating that the harms of the criminal process reach everyone involved. There's a growing body of research, including a project I've just begun with Nicola Tyler from the School of Psychology, who I don't know if she's here tonight. Hello. That shows the harmful emotional impacts on both lay people and criminal justice professionals. Then, having highlighted some of the ways in which the criminal process causes more harm by attempting to be unemotional, I'll say a little about why I think we haven't properly addressed or even recognised some of the problems in the criminal justice process. while we have a number of high-level recommendations from recent reports, I'll talk about the fact that we're stuck in this particular kind of approach to criminal law reform, and that reform is largely siloed from other matters of social justice. It's therefore unsurprising to me that we've made little progress in addressing the problems in the criminal process. Then finally, I'll move to the hard part. I'll finish off by talking about what I see as some viable steps towards making a change, what I call let's try to get warm. How can we build on some of these initiatives that have already begun? How do we warm up those cold hands of the criminal law, make the process a proper shelter where people can trust that harms will be responded to safely? Now, criminal law is about people's stories. It's about their histories. So I'll start by sharing what motivates me, and the kids have to stay there while I do it. And I'll also share with you one of my own stories. Now, most of my formative years were in the UK in the Thatcher era. I lived in a mining village, and during the miners' strike in the mid-80s, I saw the impact of police misuse of power on the picket lines. Later, when I was a student, I protested my right to party. There was an actual rally, it's not just a Beastie Boys song. And I experienced some of the special police treatment myself. When I think about my research life, seemingly disparate projects I've worked on, from eyewitness identification, sexual violence reform, evidence law reform, juries, sentencing, they can all be linked by a motivation to improve the experience that people have with the criminal justice process. That stems back to the unfairness that I saw when I was young. Those early experiences sowed the seeds for the research I do and the questions I want to ask, and ultimately my ideas about reform of the criminal justice process. I've been lucky enough to be involved in some projects that have led to legislative reform, but I've learned that policy and practice change are just as, and sometimes more, influential. I am a socio-legal researcher. It's like I'm a socio-legal research anonymous here. It's a term that isn't very easy to define because people view it in different ways. But at its most basic, what it means is I take a multi- or interdisciplinary approach to the study of legal phenomena, using both theoretical and empirical methods. For legal academics like me then, theoretical perspectives and methodologies are informed by research undertaken in disciplines outside law, as well as by traditional legal research and theory. Of all branches of law, the criminal law is where the power of the state is the most visible. Ultimately, decision-making in the criminal justice process can deprive people of their liberty. The criminal justice process causes harm while it's responding to harm. I'm not referring here to harm in the very strict definition of violation of a person's interest as is required for criminalisation, but more in a general sense of physical or psychological harm caused by some loss. For me, the idea of criminal justice as something harmful that was experienced as something that happens to people, something that's intensely personal and emotional, started even before the miners' strike and those rallies to preserve my ability to attend raves. It started with family stories about the 1930s kidnapping and murder of my grandfather's cousin, Mona. There she is. She was 10 years old when she was kidnapped and killed. The stories that we heard in the family focused on the family's frantic search for Mona and subsequently for her body over days and weeks and months. And here are some local women about 3 weeks after she'd disappeared searching in the gully. That sense of loss and panic was what came through those stories, the momentous impacts it had on extended branches and future generations of our family. Later on, I read Mona's case. I read about about it through several books, articles. Often it was that 1960s style of reporting on true crime. The case was notorious. It was important because it was one of the last no body, no murder cases. And it went to 2 trials. One for kidnapping, before they found her body, and then another for murder, after they had found it in this river, the River Idle. But because to me the case was personal, what affected me most was the suspicion cast on Mona's family, the blame placed on her parents for being ineffectual, essentially because they were poor and uneducated. That, to me, was a message about the criminal law that went beyond the intellectual and legal aspects of the case, even though they fascinated me later. It was the human element, the emotion, the ongoing intergenerational pain that resonated first. Public interest was prurient in the case. No body, a psychic medium employed in the search, tales of infidelity. Police and the courts were distant and aloof for Mona's family, officialdom that unemotionally handled a part of their profound grief. The criminal law and its agents had cold hands indeed. It's too easy to forget that people involved in a criminal case are more than that moment of offending. My family were more than that moment. People come into the criminal process with complete life histories, full stories. And as I look at the criminal justice process today, their treatment is not much better than my family suffered at the time of Mona's disappearance. Those living in poverty are still more likely to be offenders, more likely to be victims, more likely to be blamed for what happens to them. In New Zealand, because of a colonial taking of political power, they are also more likely to be Māori. It's apparent then that the criminal justice process harmed some more than others. Much criminal justice research understandably focuses on the inequities of the criminal process, as I've just described, for suspects, defendants, and offenders. New Zealand has an adversarial criminal justice process, whereby parties put forward competing narratives about what the truth is, and the prosecution must prove the case against the defendant beyond reasonable doubt. And that's a term that continues to confuse law students and juries alike. Unlike civil law jurisdictions such as those in continental Europe, the parties decide what witnesses to call. The judge acts as an impartial referee. While the trial is touted as this ultimate focal point in our system, in reality, most criminal offences don't go to a defendant trial, much less a jury trial. Most defendants are dealt with in a way that's much more perfunctory than popular culture would have us believe. Along the way, there are incentives to plead guilty, both explicit, through things like a guilty plea discount, and implicit. So for minor offending, it can seem easier to plead guilty to get it over with. Getting it over with is an understandable aim, when, to use Malcolm Feely's famous phrase, the process is the punishment. The phrase denotes the problem that, from the very first connection with the criminal process, defendants' lives are impacted. Employment can be affected, relationships, reputation, and so on, often before adjudication takes place by way of a guilty plea or defendant trial. Add to that we are punitive in New Zealand. Our imprisonment rate is, on the latest figures, approximately 170 per 100,000 of the general population. So that's improved from 5 years ago, but it still puts us in the top 10 in the OECD, and that is not a list we want to be near the top of. As a point of reference, England and Wales sits at around 135 per 100,000. Most of the Nordic countries are around 60 per 100,000. Our remand population, so that's the prisoners who have not yet been tried, not yet been found guilty, is 62 per 100,000 of population. We imprison people who have not yet been convicted at a higher rate than some countries imprison, full stop. So Feely's idea of the process being the punishment still rings true in modern day New Zealand. It's now well known and accepted that Māori suffer these ill effects of the criminal justice process more than any other group in New Zealand. They are overrepresented in criminal statistics, from arrest through imprisonment, and including remand in custody. The harms are undeniable. Just under 17% of the general population are Māori, but approximately 52% of the prison population. The impacts of colonisation, the loss of Māori political power, are very much present in our criminal justice process today. Harms to whānau continue despite promises of reform. So, the criminal process, undeniably harmful to defendants. And my own early motivations, interests and reform plans revolved solely about addressing those harms that I saw to suspects, defendants and offenders suffering because we're in this process that doesn't work properly. But then I had an experience as a survivor of crime, of violent crime, when I was a postgraduate student. And that made me broaden my scope a little bit. Nothing like a good bit of personal experience to make you think hard. So it was a very good life and research lesson for me in the harms that the criminal process inflicts on victims of crime. So at the time, I was doing some part-time work in defence. I knew the process, I thought. I was pretty confident everything was going to be okay and that I knew what was going to happen. I was not kept well informed by police or the prosecution. I was shocked on the day of the trial to find out that charges had been amended in order to bargain a guilty plea. And even though I expected it, I did get upset later that I had to hear pleas in sentencing submissions that were distortions of the truth, with no way for me to respond. Even knowing the system as I did, working for the defence, knowing prosecutors, I wasn't expecting to feel quite so much of an outsider to proceedings about harm that had happened to me. My experience was over 25 years ago in the UK. But it doesn't take much to look around in New Zealand to see that the experience of victims today is still poor. Victims put trust in the criminal justice process and the people working within it. But within an adversarial process, victims are not parties to the offence. While there's a common perception that our criminal justice process is highly individualised, and it's true that we have a focus on protecting individual rights, a criminal prosecution is ultimately a communal process in the sense that the state represents the community. It doesn't represent an individual. So that's intended to relieve victims of the burden of bringing actions for harms committed against them. But its result is, as the legal scholar Andrew Ashworth famously said, as far as the adversarial system is concerned, the victim's interest is surely no greater than yours or mine. And that's what I felt when I went through the system myself. Meanwhile, communities that suffer other forms of social injustice are overrepresented as victims and as repeat victims. Māori in particular are overrepresented as victims of violent offending. Reporting rates for violent crime, particularly of sexual violence, are low. Fear of crime is high. Reforms to victims' rights legislation has tended to merely pay lip service while making little appreciable difference to the actual experience of victims in the process. And that's because the process is not designed to give victims a greater role. This has all been exacerbated by the tendency to cast victims and offenders as two disparate groups. Yet not only do victims and offenders both come from our community, they are often the same people. If ever a shelter was pale, It's the one provided to victims of crime. Now, while the harms caused to defendants and complainants by the process are well researched, and I've just given you a very quick snapshot, my argument is that the harms inflicted by the way we do justice go well beyond those groups. We know that the effects of the criminal process itself, as well as offending behaviour, ripple out to Fano and beyond, as it did for my family in Mona's case. But what's less well documented is the impact of the process on other actors within the criminal process. While most research focuses on the dehumanising effects for victims and defendants, there is nonetheless a growing international body of research that shows both positive and negative emotional impacts for others in the process, including judges, lawyers, police, and other criminal justice professionals. And I want to briefly illustrate that by looking at two groups, jurors and prosecutors. And these are the groups where, coincidentally, I've done empirical work with. So I'm going to share with you this evening some of the things that jurors and prosecutors have said to us when we've been conducting the research. So, in terms of jurors, there's very little research internationally on the impacts of criminal justice on jurors. We're one of the few countries in the world that has had large-scale qualitative studies with jurors in real trials. And I've been privileged to be involved in the two largest of those studies. When I first came to New Zealand, I was warned by my PhD supervisor, Professor John Baldwin, that I was coming to a wasteland, I said it quite like that, for criminal justice scholars, because New Zealand had very little crime. I was very fortunate when I arrived that Warren Young, who's here tonight, and Neil Cameron, who unfortunately can't be, were here at the law faculty of Victoria. I feel lucky to have come to a place where applied criminal justice research was taking place in the law school, where it was revealed to me there was indeed crime. And of course, there was lots being done by colleagues such as Professor Jan Jordan and others at the Institute of Criminology too. Without Warren and Neil, it would have been really difficult for me to follow my passion of socio-legal empirical research on any large scale. I learned so much working with them on the first New Zealand jury study. And I do confess, this is not very nice of me, but I had a little bit of glee when Professor Baldwin, who was a juries researcher, ended up being very jealous that I was able to conduct research that was prohibited in England and Wales. Not such a wasteland after all, John. Now, many jurors enjoy the experience of being on a jury, but a significant minority are emotionally impacted in ways that disturb their well-being, family life, and work. What we've been told by jurors illustrates that the harms caused by the criminal justice process are not confined to victims and defendants. Some of the emotional harm is unavoidable, just by the nature of the evidence. But how we respond to that and the extent to which it has to be disruptive of jurors' lives is something the criminal justice process can do something about. Now, I obviously don't have much time this evening, and you all want to get to the drinks. So I'm just going to give a brief snapshot of three aspects of juror stress and emotional harm. So first of all, many jurors, even those who are positive about the experience, talked about how draining and emotionally tiring the process is and reported times of emotional release. So one said, you almost feel like a victim. It was really stressful, intense, and scary. I couldn't stop thinking about it, and because you are instructed not to talk to anyone about it, you can't deal with it. It's quite an emotional thing. Coming out on the Friday, when we had finished, I met my wife at the pub, and when I was waiting for her, I was shaking. And this next one is about people suffering pretty much sleepless nights during and after the trial, and those effects lasting well long after the trial, their inability to let it go, causing lots of stress in their relationships. This one said, I had an argument with my partner the first night because he thought I was ridiculously upset. He couldn't understand it at all. And the following day I found out most of the women went home and burst into tears. Upset and distress is often more acutely felt, as you would expect, in violence and criminal violence and sexual violence trials. But it can also manifest in other types of case, particularly longer trials. And we had a few fraud cases, for example, where people said, look, I've made connections with these people over the course of 6 weeks. And then you just say, thanks very much, see you. You're, as the juror said, just thrown out at the end. Jurors not only find the evidence itself upsetting, but also the stress of deliberations, dealing with their fellow jurors, 12 people shoved together in a poky little room. Things are not always going to go well. Some jurors, when talking to us, cried during their interview, recalling exchanges with other jurors and the level of tension in the jury room. That tension relates to a second aspect of emotional harm and stress. Jurors can become distressed by the pressure to reach a correct verdict and the impact of their decision on the lives of defendants, complainants, and their whānau. So the first one there said, all of a sudden, I thought when I was sitting in the jury box, I had to decide someone's fate. I didn't know how overwhelming that would be. I never want to go through it again. I never want to have it on my shoulders to put a guy away. We were all in tears. I was physically ill. And this last one was from a murder case. We got back into the jury room after the judge handed down the life sentence, and 12 people. There was just not one word, just dead silence. A couple of women cried. I cried when I got home. I drove a male juror home, and he had a cry on the way home. It was pretty emotional for everybody. Pressures about the verdict are exacerbated when members of the jury are affected by evidence because of what they or someone close has experienced. And our studies suggest this is most likely to happen in sexual violence trials. As well as the personal impact on individual jurors, which is profound, in a small minority of cases it can be disruptive of juror decision-making, as in this case, which has stuck with me. This is from our first study, and it is, and Warren's nodding his head, it sticks with you so much. Imagining what that was like in that jury room. For most of the time, she did not sit at the table with other jurors, and at one stage she curled up in the corner in a fetal position. Now, so far I've looked at the harmful impacts of the criminal process on lay people. There's a growing body of research, as I said at the start of this talk, about the impacts of emotional labour and vicarious trauma on the well-being of those working within the criminal justice process. There's very little New Zealand scholarship about it, though. So we're quite excited about this study, aren't we, Nicola? Which in the first phase examines prosecutors and defence counsel's experiences. So thanks to Nicola and also to Rachel, who conducted interviews with prosecutors for her master's thesis research, for agreeing to let me share some of these quotes with you. The data is extremely rich. So again, I'm just going to share a small taster with you. So first, almost all of the prosecutors we spoke to told us that they felt the need to switch off their emotions. When asked the question, do you feel that there are certain emotions you're expected to perform as a Crown prosecutor? One prosecutor said, if detachment is an emotion, I feel more often my job calls on me to hold something back that I naturally feel. And another said, you can't be emotive as a prosecutor. You can't cry, you can't get angry, you have to be completely lacking in emotion, which, I don't know, I guess it's an emotion, but devoid of emotion is the emotion that you have to be. Secondly, this need to work without being impacted emotionally fed into a sense that to feel emotion or to admit to needing support was weak, or it showed they were not up to the job. This, understandably, seemed to impact on junior prosecutors the most. They were the ones most fearful about what would happen to their career. So one of them said to us, some of the older partners can't see why we're not tough enough. And there was talk of aspiring to be like the senior partners who all seemed to bounce off of, and they didn't get emotional at all about all of these horrific things they were doing and seeing. And then another said, I felt all the weight of my bosses telling me and my colleague, it shouldn't matter to you that much. Don't let it get to you. Just don't let it get to you. So as you can start to see from those quotes, it appears that the culture of firms and the profession more generally help to create the feeling that to have career advancement, you should not show your weaknesses. So occupational culture is related to these fears about career advancement. And one prosecutor, and we also talked to the person involved who confirmed this, it was suggested to one of my co-workers the best way to get over her 3 rape trials in a row was to have a stiff glass of wine, which I think wasn't what she needed to hear at that time. And that does feed into a coping mechanism of excessive drinking in the criminal legal profession. And then this next person, there's very much an expectation. You'll just get on with it. You can't be weak or fallible. I don't think you would advance professionally in the firm if you were to admit to being damaged. I mean, it's okay to joke about it, but not to seriously admit to the effect the material has on you. It's implicit in that no one's ever said, don't ever tell us if you have a problem. But there's a lot of taking the piss out of anyone that does admit to being vulnerable. So it's very clear you wouldn't do that and still be held in high regard. And when we probed a bit further, the people taking the piss were the partners. Okay. So it wasn't just kind of fellow on the same level as those juniors. There was very low enthusiasm amongst the prosecutors we've spoken to so far for EAP processes or the Law Society advice lines. They reported that they would rather see someone else. Some firms had put in place some mechanisms, but prosecutors reported to us that there were barriers to confidentially accessing other counselling through their firms. Oops, sorry. The constant having to push, said one, was wearing me down. I'd rather go and pay for it myself than have to keep going and filling in all these forms and begging, have you made a decision, have you made a decision? And then another said, there's a new service, but it's not encouraged. It's certainly not encouraged. They started offering clinical psychologists that you can go to, but it's been described as the last cab in the rank kind of service. We should be front-footing these issues because a lot of the things I've said to you now, I know, saying it out loud, that's not right. And I shouldn't be thinking like that. And I know a lot of people would be horrified if they found out the prosecutor was thinking things like I'd said. And then thirdly, the role impacts on prosecutors' well-being. The process and how they work within it impacts on their well-being. It leads to those coping mechanisms like excessive drinking, lots of use of dark humour. And as I read through our data on this when I was preparing for this lecture, it reminded me very much of things I'd read many years ago about police in the UK and the things they said about their role. I feel like I'll never be able to be just a normal person after reading all this stuff. You just can't. You cannot. So much stress. You can't eat properly. You can't sleep properly. It's a bit of a nightmare, if I'm honest. And then another said you're exposed to a lot of trauma and you just kind of push it aside till it becomes too much and you can't cope. And for those who can't cope, what we got were reports that people were just crying in the bathrooms, being very upset in a closed office, those kinds of things. Now, this included impact on their relationships, and this to me is so sad. So this is not just about their working environment, their working life, it's impacting on their relationships with people outside of the office. Prosecuting sexual violence affects my life. If I'm in trial or the lead up to a trial, my job is to vividly paint a picture of sexual violence. My head is busy trying to recreate a picture of sexual violence, and it's stewing over that in my subconscious. And there is no way I've found to be physically intimate with my partner. I just don't want my husband. I don't want to be halfway through having sex and suddenly my mind draw up the image from 2 p.m. today of sexual violence. Now, it goes further than that. It affects every part of these prosecutors' lives in the way that they look to the rest of society and they look and think about human nature. Creating this general kind of sense of suspicion and almost paranoia. So one prosecutor was talking about when they were on holiday at a campsite, and this was the internal track going through their mind. Do you think those girls are safe with their dad? Why are they just with their dad? Where's their mum? What could be happening in that tent right now? When I've woken up in the night, I've thought, is there someone in the house? Could someone come in the house? There could be someone going to do a burglary. There could be someone coming in to look for a woman to rape. It's a fear or an anxiety that I never had before. And that next one, this sort of like simple innocence has gone. I think that's a wonderful way to put it, that this innocence has been taken away because of their work in the criminal process. They said, so like before, I used to drive past campgrounds at the beach or people camping at the beach and think, oh great, these people are having a nice holiday. And now I drive past a campground and I think there's definitely going to be at least 10 kids getting molested in there. And the people who are committing the offending, there's no way to know what they look like and no way to know who you should be suspicious of and not. So you just end up being suspicious of everybody, unfortunately. Now, I should make it clear, I'm not suggesting that we could or should attempt to make this vicarious trauma and emotional labour of working in the criminal justice process magically go away. The point is that we're not addressing it in healthy ways, and therefore the process is more harmful than it needs to be. The problems that these prosecutors have identified are mainly ones of harms caused by the suppression of emotional response. Working in the criminal process will always expose people to vicarious trauma and require emotional labour. But that doesn't have to be unrelentingly harmful and negative in the way these prosecutors describe it. Acknowledging emotional impacts, supporting people to get help, for example, through professional supervision, as has been suggested in the profession, can actually lead to positive impacts. Psychological research shows that there are possible positive outlets for emotional labour, and that if harnessed, it can sometimes help people to do their jobs well and to do them more safely. So, what these examples of the harmful impacts of the criminal justice process illustrate is a form of dehumanisation, a disconnect between the law, the human beings that inhabit the criminal justice process, and wider society. In turn, it suggests that, while important, changes to the law alone will not fix the failings of the system. In the early 1990s, I was studying at Birmingham Law School, and it was perhaps at the time the best place to be for someone interested in criminal justice, because the Birmingham School was this powerhouse of empirical, socio-legal and critical criminal justice research. The Birmingham Six famously had their conviction quashed at the time I was there. It was the site of fruitful police research, and that was something I benefited from when I did my PhD research across several police stations in the West Midlands. Now, while I was an undergraduate, Birmingham and ex-Birmingham scholars McConville, Sanders and Leng produced the landmark book Case for the Prosecution, which illustrated that police discretionary decision-making had not been fettered by legislative changes to police powers. Roger Leng, one of the authors of the book, was my criminal law lecturer at the time of its publication, and he later became a mentor and friend. And seeing his passion close up was really inspiring. Now, one of the mainstays of the book is the critique of what it terms the legal reform model. While focused on police powers, I'd argue that the critique has more general applicability. McConville, Sanders and Leng describe the seductive and understandable response of trying to amend legal rules to protect individual defendants and increase the role of victims. And they say to advocate reform of this kind implies that social actors are responsive to changes in legal rules, and that the response is that which is contemplated by the advocate of reform. So in other words, successful legislative reform requires that the new law does what it was intended and that the people using it or governed by it change their behaviour accordingly. Now, while McConville, Sanders and Leng found that changes in legal rules had some impact on the behaviour of actors within the criminal justice process, the changes often instead produced adaptive behaviour that undermine the intentions of the reform. We can't rely on the law alone as a protective device. Otherwise, we will slip, say the authors, into a treadmill of permanent law reform in which every failing of the law to deal with certain social behaviours is addressed by a reformulation of the rules. Now, that may sound familiar to any of you who have been involved in criminal justice reform in New Zealand. Now, time and criminal justice have moved on, but case for the prosecution, and particularly that critique of the effectiveness of reform of the law itself, remains relevant, I posit, in two ways. First, if legal scholarship and reform only looks to legislative amendment or legal reasoning about a set of established legal norms, we may silo those reforms and the process as a whole, resulting in what has been called law without society. Rule changes need to be mindful of cultural work practices. We know that cultural norms in police and the legal profession are not altered easily. Criminal justice can and should fix things that are within its own house, but the problems of criminal justice are related to the problems of society as a whole. That means that even reforms that attend to criminal justice practice rather than legal rules need a broader frame in order to be able to have optimum effect. We cannot make criminal justice better without also attending to social deprivation, which both drives and is fed by criminal justice outcomes. The legal reform model does not adequately address inequities and bias. As reform recommendations coming from the Safe and Effective Justice Whois and advisories suggest, we need to both think about what we mean by law and also be prepared to look beyond it for ways to make the process better. Secondly, the case of the prosecution remains valid because just as in the 1990s in Britain, New Zealand's current criminal justice process is a place where policy and practice are quasi-legal beasts. In our criminal process, discretionary decision-making is common and is necessary, but even putting aside the problems with working out how much discretion is required, that's a lecture on its own, it can leave the criminal process quite vulnerable. So, for example, police adult diversion is a policy that could be withdrawn by police if they wanted to, even though that would have significant impact for the running of the courts. Now, one might argue that those policies should all be given a legislative base. But the limitations of the legal reform model would remain because discretion will still be needed, and discretion is notoriously resistant to changes in the law itself. So a good example in New Zealand of this is sexual violence reform. Incremental reform of evidential rules, and to a lesser degree, the substantive law, have been a feature of the last 30-odd years. We've instituted a lot of worthwhile reforms. Many of them have had impact. We've allowed complainants to give evidence in alternative ways, provided for support people, controls on questioning, particularly regarding a complainant's previous sexual experience. We've revised for gender neutrality in the language of the statute, and so on. But despite that multitude of reforms, and despite the positive effects of them, reporting rates remain low, prosecution rates remain low, and conviction rates remain low. Complainants continue to find the process punishing, and rape myths are still prevalent in court. We're reaching the end of the road in how much more we can tinker with the evidential rules, and without major disruption to basic principles, how much we can alter the substantive law. The legal reform model has not worked because, just as McConville, Sanders and Lang identified back in the 90s, reform to the law itself can only do so much without change to underlying culture and society. So, let's try to get warm. How do we make criminal justice better? So, I feel that I may have got you all feeling quite depressed, quite despondent. It's not an unusual or uncommon response to my talks. I've argued the criminal justice process is harmful to everyone within it. Traditional legal reform is necessary but not sufficient. So do we throw up our hands in despair? Do I think I had a flash of it as I was writing this. Have I wasted my time all these years? We can't afford to do that. And in fact, what we know about harms caused by the process and the limitations of the legal reform model can start to illuminate some avenues of potential change. And I'm going to mention three. I've got a thing about three in this lecture. It wasn't intentional. The first one is one I've been an advocate of using in sexual violence cases for a decade now, but there's no reason why it should be restricted to that type of case. Many of the harms we see come from the nature and operation of the adversarial process. Our modern criminal justice process is young. We need to have some of what Lucia Zedner calls gentle eye-opening. If we try to open our eyes to other ways of doing things, we might see that there's no magic to the adversarial trial. It's not a necessary given, certainly not for all cases. So my argument is we should look to alternative processes. What we need is a suite of options. The defender trial is only one of those options. Now that would work especially well for cases where we don't have enough evidence to bring a prosecution, or where there's sufficient evidence to prosecute, but the prosecution is unlikely to achieve an outcome that addresses the needs of the victim or be in the public interest. In those types of case right now, harm often goes unaccounted for because the criminal process fails to achieve any kind of redress for that harm. So within this suite of options, broadly restorative, therapeutic and educative approaches could operate. That might be within the criminal justice process and even within the courts, such as the Te Amarama initiative, that would see, among other things, community services on hand for advice and support. But the different approaches might also operate outside of the formal criminal justice process, or as diversion from it. These could include a community problem-solving approach. That would go further than the current Te Pairanga Iwi community panels. I'm talking here about something that where we'd have support and programs on hand, not only for defendants, but for victims and perhaps for families, and being community-led and run. The provision of educational programs relevant to the offender. A treatment response for the offender that sits outside of the criminal process, so that we're not, as we tend to do in problem-solving or solution-based courts, holding on until sentencing and forcing treatment during that phase. A restorative justice type response that would involve a direct or indirect mechanism for the victim to present to the offender the consequences of their conduct and for the offender to acknowledge their wrongdoing and offer redress. Now, these types of reform would help to locate criminal justice within the broader social justice needs of offenders, victims, and communities. It would also allow for communities to have ownership of responses to harm. That could go some way to avoid the problem we often see of co-option of Māori knowledge, experience, and political power when we devise new programs in the criminal process. Secondly, real effort. Anyone from the government here? Real effort should be made to translate those high-level recommendations that we've seen for transformative change into meaningful options for the individual parts of the criminal process, as well as looking at the whole. Now, that's a really hard job, but somebody needs to attempt to see what would these reforms look like for different stages of the process in its niggly, itty-bitty detail. Otherwise, we're going to continue for another 30 years without any meaningful change. That kind of effort should show respect for Indigenous knowledge by empowering Māori and other communities rather than taking place solely within existing policy frameworks. And thirdly, for cases where we must go to trial, we need to more openly acknowledge the positive role for emotion. Law and language research has shown that emotion is not the antithesis of reason, as lawyers would often have you believe. In fact, rather than being the enemies of reason, emotions have positively influenced the development of legal reasoning, practice, and scholarship. Neuroscience suggests it's impossible to separate emotion from reason, and we shouldn't try to. Emotional labour does not have to be negative. Emotions matter for justice. Now, recognising that valid role of emotions in decision making could assist in the courtroom. So thinking back to those quotes from jurors, we could give jurors better emotional as well as factual preparation. We could have greater emphasis on the benefits of counselling, not just an offer of counselling, but a positive encouragement or expectation. And we could give them preparation for the difficulties encountered when undertaking the responsibility of being asked to judge other people's lives. And we could also give them more education about group decision making. Some of the stress and pressure jurors endure, as well as inefficiency in deliberations, could be ameliorated if jurors had help with how to go about making a decision. Now, we found in our recent study that question trails help, but jurors still struggle. Recognising that validity of emotions can also humanise the criminal justice process and thereby reduce harm. I'm going to give you a final quote, an example of a judge humanising their court that shows the difference it can make, not just to defendants, but to whānau, supporters, lawyers, and it probably made a difference to the judge as well. The judge turned to the gallery and just said, "Does anyone have anything they want to say?" And the defendant stood up and said, "I'd like to say something." And he pretty much spoke to the family of the victim who died in the gallery, and just to ask his friends and family who were there to support him. And he was given the opportunity to apologise and to address everyone. So that was such a lovely thing to happen. This quote reminds us we can do better. An approach that recognises everyone's humanity should not be unusual or comment-worthy in an inaugural lecture. More diversity in the profession, in criminal justice agencies and academia would be a really good start. We've not even touched the tip of the iceberg in finding out more about what Pacifica and Asian communities need in order to be able to adequately access criminal justice. Perhaps a good place to start is to support people from those communities to do that work. So, I've thrown down a wee gauntlet this evening for the profession, the academy, politicians and the wider community. For criminal justice reform to work, we need to change our mindsets about the criminal justice process, about emotion and well-being within it, and what reform should look like. We won't get anywhere near aspirations like decarceration if we don't. So much more can be done to heal and improve criminal justice, to make it better and warm up those hands and heart. Thank you.
Hei te tini, hei te mano, e rau rangatira mā, tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Mark Hickford, taku ingoa. My name is Mark Hickford. I've been privileged to serve as Pro-Vice Chancellor and Dean of Law here at Te Herenga Waka, Victoria University of Wellington, since the 11th of May 2015. In closing, before we partake in refreshments beyond these lecture theatre doors to my left, I propose a vote of thanks for our colleague, Ahorangi Yvette Tinsley, Professor Yvette Tinsley, for her inaugural lecture this evening entitled Pale Shelter, Cold Hands, Making Criminal Justice Better. One of the distinct pleasures of serving in my role is to have wonderful academic colleagues such as Professor Yvette Tinsley. Her work is assuredly and proudly socio-legal. Professor Tinsley muses on the possibilities of change, seeking to get underneath lived behaviours and practices. She undertakes this effort while also analysing the limitations and infirmities of legal reform if that reform is understood as simply requiring one to merely adjust legislative or other legal settings, or limiting one's thoughts concerning criminal processes to justice sector institutions and their practices. Hers, then, is an enlarged vista, one informed by diverse communities of research endeavour. She joins with colleagues from psychology and criminology in exploring the emotions and emotional labour of criminal processes. In this venture, as set out in her lecture this evening, Professor Tinsley exhibits the profound patience required in scholarship, the willingness and curiosity to examine different angles of vision, ways of seeing, speaking, and doing, as well as being. Her lecture recognises the seemingly incremental toil of scholarship, day by day, week by week, month by month, cumulatively yielding greater insights across time. Yvette's familial and intellectual whakapapa does not merely reside in this archipelago, or in the islands and ocean roads, the whakamoana of the Pacific. It lies many miles distant, in the northern parts of England, in the United Kingdom, specifically narrated through tales of whānau, in the village of Huthwaite, in Nottinghamshire, as well as her beloved university in Birmingham. I was about to say Brum. She has recounted her memories to me of the Thatcher period, her fondness for aspects of early 1980s music as well as the later decade music. So she has mentioned, for instance, Joy Division and Mr. Curtis, Love Will Tear Us Apart. I won't go on about Spandau Ballet or Duran Duran. As we have witnessed this evening, there is a warm, lifelong arc woven through this lecture. I was thinking of Seamus Heaney, the poet, who said, "Sow hope for a great sea change on the far side of revenge. Believe that further shore is reachable from here. Believe in miracles and cures and healing wells. With our eyes cast towards these horizons, our colleague challenges us to acknowledge the emotions of justice and the fact that emotions matter for justice." Yvette Tinsley started her lecture with an excerpted image from Henry Moore's famed piece entitled Pale Shelter, dating from 1941, during the grave, perilous uncertainties of war, when death visited from the skies in her ancestral homeland. It is an image representing groupings of layered humans sheltering in the London Underground. That art was exhibited in the National Gallery in London in 1941. The catalogue described it as a vista of recumbent shapes, pale as all underground life tends to be pale, regimented as only fear can regiment, helpless yet tense, safe yet listening, uncouth, uprooted, waiting in the tunnel for the dawn to release them. For the dawn to release them. You would have heard in our colleague Yvette Tinsley's lecture this evening reference to Te Ao Marama, which can be translated as first light, or the illuminated world, or the dawn-lightened day. Yvette Tinsley exhorts us to pursue the warmth of the brightening day, to see beyond the institutions and structures of criminal justice as they are. So please join me in closing. Thanks for our colleague and her lecture this evening. Thank you.